Hello everyone, I'm Sahil Kumar. Today, I'll present an overview of anti-suit injunctions or ASI within the framework of English Private International Law. An anti-suit injunction or an ASI is a court order directed at a party, whether an individual or a corporate entity, prohibiting them from initiating or continuing legal proceedings in a foreign jurisdiction. In essence, it allows a court in one country to restrain a party from pursuing litigation elsewhere, typically to uphold its jurisdiction, enforce contractual forum agreements, and maintain efficient and fair dispute resolution. ASI are especially significant in international commercial litigation, where parties may engage in what's called forum shopping, choosing jurisdiction perceived to offer procedural or strategic advantages. This practice often leads to fragmented litigation, inconsistent judgments, and increased legal costs. By granting an ASI, a court ensures that a dispute are resolved in appropriate or agreed forum, thereby preserving legal certainty and judicial economy. ASI may be granted to enforce exclusive jurisdiction or arbitration clauses, protect litigants from vexatious or oppressive foreign proceedings, or prevent abuse of the forum's process. They are particularly justified where foreign litigations threatens to undermine the integrity or effect of a domestic judgment. Ultimately, ASIs enable the courts to preserve fairness and manage cross-border disputes with coherence and authority. Now let's look at the early application and development of ASI. The origins of anti-suit injunctions in England traces back to the 15th century, where the Court of Chancery issued common injunctions to restrain misuse of the common law courts by Love v. Baker, 1665. The injunction extended beyond domestic courts, with the court preventing proceedings in Ireland. Crucially, such orders were addressed in personam. They targeted litigants, not the foreign courts, thus respecting comity while preserving fairness. In Bush v. Monday, 1821, Lord Eldon set a lasting foundation by holding that ASI could be used where foreign litigation were vexatious or oppressive, or in a breach of a forum selection clause. These principles were refined in the case of Societate Nationale Industriali Aerospatiale v. Lee Quick Jack, 1987, where the Privy Council clarified that ASI should be granted only when foreign proceedings are abusive and do not deprive the other party of legitimate judicial advantage. In Airbus Industry v. Patel, Lord Gough confirmed that ASI would only be granted where 1. The English forum had sufficient interest in the dispute, and 2. Where there were two potential fora, a decision that England is the natural forum. Additionally, a claimant must show that the defendant's conduct, actual or proposed, of a foreign proceedings would be vexatious and oppressive or unconscionable. In the case of Simon Engineering plc v. Butte Mining plc, 1996, the dispute had its natural forum in Brunei. However, proceedings were initiated in Texas. Crucially, Texas law would have denied the defendant the benefit of indemnity. The claimant's attempt to deprive the other party of substantive right was deemed unconscionable, justifying the issuance of the anti-suit injunctions to prevent the claimants from pursuing foreign proceedings. These developments underscore the nuanced application of anti-suit injunctions, balancing the need to prevent forum shopping and protect substantive right with the principles of international comity. Now, we look at the second key justification for the grant of ASI, which is the preservation of English jurisdiction clause, which preserves English JA. In Donohue v. Aramco, despite a clear contractual agreement to litigate disputes in England, the defendant commenced proceedings in the United States. The Court of Appeal, led by Lord Justice Broke, granted an ASI to restrain the foreign proceedings and uphold jurisdiction clause. Broke LJ emphasized that the legal approach should be symmetrical. Where proceedings are brought in England in breach of foreign jurisdiction clause, the English court will state its own proceedings. Conversely, where proceedings are brought abroad in breach of English jurisdiction clause, the English court may intervene by issuing an ASI. However, this approach was narrowed by Lord Hobbes in the House of Lords, who maintained that the mere existence of English jurisdiction clause does not automatically entitle a party to injunctive relief. Rather, there must be strong reasons to justify such interference with the foreign court's proceedings. In Donohue, those reasons were absent apart from the jurisdiction clause. The case had little connection to England, and the United States arguably had the more appropriate forum. The restrictive approach was further entrenched in Turner v. Grovit, where Lord Hobbes clarified that an ASI should be granted only where there were ongoing proceedings in England that required protection. This development reflects a significant tightening of ASI doctrine and demonstrates the court increase in reluctance to intervene in foreign proceedings without compelling justification. Now, I will pass to my group member Alea, who will take us through the next point.
Hi everyone, I'm Alia. Today I'll be breaking down the legal problems surrounding anti-suit injunctions or ASIs here. In particular, I will discuss three main topics. The first one is if ASIs constitute judicial overreach on an extraterritorial level. The second one is if a solid foundation is offered by the comity doctrine. And lastly, the conceptual differences regarding ASIs between the House of Lords and UK Court of Appeal. Now let's consider the nature of ASIs. These injunctions are often controversial because of their extraterritorial reach. Courts typically distinguish between two types of ASIs. First, orders directed at a party preventing them from commencing or continuing foreign proceedings. These are often seen as arguably justifiable with cases like Love versus Baker and British Airways versus Laker Airways offering precedents. Second, orders that directly enjoin a foreign court. These are much more contentious as they represent a direct interference in other nations' judicial process and are widely considered unjustifiable. Anti-suit injunctions are strange. On the surface, they don't bind foreign courts in cases where they bind the parties involved. However, in reality, they obstruct foreign courts' jurisdiction in an indirect manner. This begs the question, is this an illegal exercise of international court authority? When the enjoining court instructs a party not to proceed in a foreign jurisdiction, critics argue such ASIs violate the concepts of sovereignty. Even if it is officially addressed at the party and not the foreign court, the unilateral measure is frequently viewed as an intrusion. ASIs therefore frequently have the appearance and possibly the impact of extraterritorial jurisdiction interference, even if they are legally permissible in common law regimes. Now, let's look at a critical issue surrounding anti-suit injunctions, which is the lack of clear guidance in case law. Although courts have dealt with anti-suit injunction in various cases, the principle they rely on often appear inconsistent, even vague. One of the most important cases in this area is Airbus Industry versus Patel, where the Lord Gough attempted to clarify the court's role. He emphasized a central idea. Committee requires that the English forum should have a sufficient interest in or connection with the matter in question. This statement was intended to set a limit on when English courts could interfere in foreign proceedings. In other words, courts should tread carefully and only act where there's a strong connection to England. But what is committee? The term committee was relatively new to English law at the time. Committee was central to Lord Gough's reasoning, but the problem is committee itself is vague and unstable. In Hilton versus Guyot, the US Supreme Court defined it as recognition which one nation allows within its territory to the legislative, executive, or judicial acts of another nation. But even within case law, committee is used inconsistently. In SNIA versus United States District, committee was described as a spirit of cooperation. In Somportex versus Philadelphia, it was more about practical convenience. So, what are we left with? Not a clear doctrine, but a jumble, a patchwork of vague and often contradictory statements. As one commentator aptly put it, if our brick houses of international law were held together by the fragile mortar called committee, it would have crumbled into debris long, long ago. And to make things worse, judges often mix up between the terms like Judicial Committee and Committee of Nations as if they mean the same thing when they really don't. It's unlikely that Lord Gough was unaware of this baroque opaqueness yet he avoided defining the term altogether. But eschewing definition is not a solution. Basing such a crucial piece of legal doctrine on something so unsettled, something that swings back and forth without stability, weakens the entire reasoning behind anti-suit injunctions in modern case law. Hence, Airbus versus Patel was an effort to bring clarity, but by anchoring it to the vague idea of committee, it arguably added to the conclusion rather than resolving it. So, to compare Court of Appeal versus the House of Lords, the Court of Appeal has issued ASIs even when the matter wouldn't be appropriate in English proceedings. This is judicial overreach, effectively instructing foreign courts on how to manage their cases. It implies English superiority, making gratuitous procedural comparison. However, in the House of Lords, especially in Airbus, was more restrained, some say timid. But in international law, it is better to be timid than dominant. It shows respect for foreign sovereignty and judicial modesty. In summary, ASIs are inherently extraterritorial and that makes them dangerous. The legal basis for them is uncertain, resting on the vague and inconsistent idea of committee. Courts must be highly cautious, using AHSIS only in exceptional cases or risk acting like international legal police. Now, I'll hand over to my group member Roshan, who will take us through the next point. Thank you.
Everyone, I'm Roshan. Today, I will be focusing on the position of ESI under EU law, highlighting key CUEJ case law, and examining how Brexit has changed the legal landscape for the UK. To begin with, ESIs are often controversial in civil law jurisdictions. We view them as a violation of judicial sovereignty and international committee. For example, in 1997, a German regional court of appeal in the enforcement of an English anti-suit injunction, a German court refused to recognize an English anti-suit injunction. The case involved a dispute where an English court has ordered a German resident not to pursue positions outside the contractually agreed arbitration forum. The German court ruled that only its court could determine their own jurisdictions and that foreign injunctions interfere with its legal process. Firstly, we look at the EU legal framework and the CJEU stance on ESI. The ECJ has consistently ruled that ESI are incompatible with the Brother Regulation. They undermine key principles such as legal certainty, mutual trust, and the free circulation of court decisions across EU member states. So now we look at how ESI are treated under EU law with a focus on landmark ECJ decisions. The CJEU has ruled that ESI conflict with the core principles of the Brother Recast, particularly legal certainty, mutual trust, and the free movement of court decisions across the EU. Firstly, in Eric Dasser, the ECJ made clear that ESI interfere with the jurisdictional framework laid out by the Brother Recast, undermining procedural certainty. Secondly, Turner and Godfrey case reinforces that ESI contracted EU operation by interfering with proceedings in other member states, thereby damaging mutual trust. Thirdly, the West Tankers case confirmed that ESI could block enforcement of judgment which goes against the Brussels Recast goal of judicial harmonization. Did you know the Brussels Recast replaced the EU regulation, but in the case of Nuri Holding, the English Commercial Court confirmed that the West Tanker ruling still stands as authoritative EU law. This reinforced the ECJEU position that such injunctions are incompatible with the Brussels framework and the principles of mutual trust and judicial cooperation within the EU. These rulings collectively make it clear. Within the EU, ESI are not compatible with the legal order. Now, let's look at what's changed after Brexit. Prior to Brexit, the English court was prohibited from granting an ESI in respect of proceedings brought to or threatened to be brought before the court of another EU member state, even if the parties has contractually agreed a choice of English jurisdiction. Post-Brexit, these decisions confirm that where there is an exclusive English jurisdiction clause in a contract, the English court has jurisdiction to grant an ESI, restraining parties from pursuing proceedings in a different court in an EU member state. This change restored the discretion of English court to grant ESI. As we can see in Amberley case, the English court granted an ESI restraining the parties from pursuing proceedings in Belgium, at least amounting to a breach of an exclusive English jurisdiction clause. This decision is the first in which such an ESI has been granted post-Brexit to restrain proceedings brought in breach of an English jurisdiction clause. There is a question. ESI can now be granted again. Where ESI now apply? Especially in two situations. First, to enforce English jurisdiction clauses. So, if the parties agree to settle disputes in England, the court can protect that agreement. Second, to prevent abusing or oppressive foreign proceedings, especially if England is clearly the more appropriate forum. After the UK exit from the EU, a new civil procedure rule came into force in April 2021, which is the new procedure support CPR 6.33 sub 2b clause b. This rule means that where a contract includes an English jurisdiction clause, even if in non-exclusive or hidden in standard terms, the English court has automatic jurisdiction. Importantly, claimants no longer need permissions to start proceedings in England in these cases. This made things quicker and more straightforward. This change may lead to more ESI being sought, especially to counter the so-called Italian trappetto, where a party rushed too far in a foreign court to block English proceedings. In such cases, claimants can now respond by seeking an ESI from the English court to stop the foreign claim. But we need to know, just because ESIs are allowed in the UK now doesn't mean they are easy to enforce abroad. This is because EU court may still ignore them. Following past CJEU rulings like the West Tanker case, these decisions show how difficult it is to enforce an ESI when the foreign court refuses to cooperate. So, the UK legal freedom doesn't always translate into practical power. Now, we have already known that the CJEU has completely opposed ESI to protect judicial cooperation within the EU. Since Brexit, UK courts are free again to grant ESI, especially to uphold English jurisdiction agreement. However, many EU courts remain resident, especially in arbitration cases. That's everything for me. Now, I will hand over to Shahil, who will take us through the conclusion. Thank you.
In conclusion, ASI should never come back as it may appear useful in preventing duplicative or unfair litigation abroad, but they pose significant challenges in today's global legal landscape. Although ASI are directed at individuals, they effectively undermine the authority of foreign courts, risking perceptions of judicial overreach. The principle of comity, often used to justify ASI, lacks clarity and consistency, especially in civil law jurisdictions that resist external interference. While UK courts may issue them post-Brexit, doing so risks undermining the international legal cooperation rather than promoting it. Also, cases like Turner v. Grovit and West Tankers demonstrate the EU's firm opposition to ASI.